6A-NA. Okay. All right, so we are back on record on the Collier matter for the final review. The court had also heard testimony and taken proofs on a termination request, took those as well as issued an order asking the attorneys to do their closing arguments and received those. But we've had a bit of a time frame between that last review hearing and today. So I went ahead and allowed for production of a court report and updates just in case anything had changed from the last time we were here. And I would like to ask the parties to simply consider today an additional extension on those issues, review, permanency planning, and termination as we review what's happened in the last report period. And I will certainly be giving you a decision today on the request for termination. May I have the names of our participants, please? And Ms. Collier, if you could take your hat off, please. We can't allow hats in the courtroom, and this is a courtroom even if it's virtual. Thank you.
Carson Howard, lawyer guarding ad litem.
Ms. Saja Thomas, counsel for the department. Ms. Beach.
Ashley Beach, I'm the foster care worker from Fostering Solutions.
Betsy Geyer-Sador on behalf of Carla Collier.
I'm Carla Collier, Uta's mother.
Thank you. Do we have a representative from the tribe, native village of Buckland here this afternoon? Okay. Do we know do you want to cover that in your testimony today, Ms. Beach, as far as efforts to reach out to them, or what do you think? Okay.
I can do that or give an update now, whatever you prefer.
All right. Ms. Thomas, do you have a preference or any direction for us on that?
Your Honor, just because of the ICWA implications, I would prefer if Ms. Beach could just give us an update as to the efforts she's made to ensure their attendance today.
All right. I think that's great. Dr. Ames, if you could swear her in, you can just stay where you are for now. Okay.
You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Go ahead. Or Ms. Beach, if you want to tell us about what's been happening with the tribe, if you know.
Yeah. So I have emailed the tribal representative a few times, well, more than that, probably 5 or 6 times since the last hearing. I've gotten some responses, but I did send emails on October 7th, October 10th, with no response. And then I sent the court report on November 10th, and then a reminder email on Friday about the hearing today with the Zoom ID. And then I also emailed about an hour and a half ago to the representative and the tribal admin email address with the time, date, and Zoom ID, and I have not heard any responses.
Is that Ms. Gavin that you're talking about specifically? Frederica Gavin, I think, was the last one that was here.
Yes.
Okay. Thank you for clarifying. Any questions, Ms. Thomas?
No, Your Honor.
Ms. Sador?
No.
Mr. Howard?
No, Your Honor.
Very well. All right. Let's get into the review then. Mr. Howard, whenever you're ready.
Yes, Your Honor. It's been I would say, a very tumultuous reporting period for the minor child. She really, in the beginning of October, was experiencing some pretty severe, they were aggressive and towards the family and teachers. It was mostly in the form of like temper tantrums, but I mean, that's kind of a limited way of explaining it as much more severe than that. They got so bad that they had to take the child to the ER, search for some sort of answers to get sort of help for the child. But she was discharged. They put her on a medication that didn't really work out. But over the last few weeks, and I met with the child on last Monday, the 10th, we had some really positive updates on the current medication she's on. And they, from talking with everybody, they seem to feel like they're getting her at like her baseline and starting out there. And we're hopeful that, they can continue on this medication and continue with some different service providers. They're in the process of getting her a new, specialized trauma-based therapist, as well as she was diagnosed with autism and getting some ABA therapies to really just continue to work on herself and stabilizing her. When I met with her, she was with her foster sibling, her older foster sibling, and this foster family has a lot going on, and they are kind of very, nice that they're able to prioritize and make time for all of their children in their home. And I think they have 4 kids who are all 7 years old right now. So as you can imagine, and they're all involved in different extracurriculars. And this minor child specifically is started playing ice hockey this reporting period. So I think that's just a really good outlet for her to kind of get into something else and deal with some of her aggression and behaviors that way. She claimed that figure skating was too boring for her. So, but, you know, it's like I said, a very up and down reporting period, but the most recent update is that it's very positive and this foster placement is doing a really good job of taking care of this child, prioritizing her as if she was, you know, one of their own. So I'm really glad to see that. And it was really nice to see her on last week and get to see those positive updates. Thank you.
Today, from anyone, Ms. Thomas.
Thank you, Your Honor. I'll ask Ms. Beach to be sworn in to just briefly provide her report. Thank you.
Ms. Beach, come on out to our witness stand. Remain under oath. Ms. Thomas, whenever you're ready.
Thank you, Your Honor. Ms. Beach, you've provided a court report for today's hearing. It has several attachments, but I just want to double check to make sure there are no updates or modifications that need to be made to the report or any of the attachments.
Not at this time.
Okay. And I know it's kind of been a different type of reporting period because we have already made arguments as relates to the termination request. But during this reporting period, can you just briefly summarize your communication efforts with Ms. Collier and ensuring that you're continuing to comply with the active efforts requirement of this case?
Yes, so I have tried really hard to maintain weekly or every other week contact with Ms. Collier and her attorney via email due to Ms. Collier living in Alaska. The distance to have any in-person contact is obviously a barrier. I've included our email threads as an exhibit to the court report, just showing that I'm continuing to make efforts to engage and get signatures on required documents and such. We did have a family team meeting that occurred virtually on September 19th, where we were able to discuss the services Ms. Collier was participating in, and she showed me her house virtually. That was able to occur. And then I continued to maintain contact with the tribe, or attempt to, and make sure that they're staying up to date on the child's needs and any concerning behaviors or changes in her behavior or care that I think they need to be made aware of. And then I've also invited the tribe, and Ms. Collier has been invited to participate in meetings with the school to discuss the child's behaviors and educational needs. So those are things that have happened this reporting period.
Thank you for that update. And has there been any significant change of circumstances as relates to Ms. Collier or the child that the court should be aware of that might make the agency or the court reconsider the request for the permanency goal to be adoption at this time?
I don't believe so.
I know that in the report, there was some indication from Ms. Collier's, I'm not clear if it's her therapist or a service provider liaison individual regarding her physical health and that being addressed more recently. Have you been able to get any of those medical records at this time?
I have not.
Okay. And has there been any change to the stability of the child's placement?
No, the placement remains committed to the child and has shown that they are able to meet any needs that arise.
Okay. And I know that in the report, Ms. Bloom has also indicated several times if, adoption is in fact what is going to happen for the child, that she would like to be considered. Is there any movement on an ICPC request at this time, or have you been waiting for the courts?
We've been waiting for the court's opinion just because there is an extra box that needs to be checked for adoption when making that referral for ICPC. We did previously make an ICPC referral for placement for that relative, which was denied because she said she was no longer able to accept the child. So we'll make another one and check both placement and adoption boxes if she becomes available for adoption.
I don't have any further questions related to your court report, but if there's any information that you'd like to highlight from it or your knowledge of the case, please go ahead and do so at this time.
Just that I have maintained contact with Rebecca Sullivan through Love Alaska this reporting period. She's a case manager for Ms. Collier, but I haven't been able to get in contact with her individual therapist because I don't have a release signed. And then I also haven't gotten any medical records this reporting period, to be able to see what Ms. Collier has been experiencing medically. But other than that, I don't feel like I have anything else that needs to be highlighted verbally.
Thank you. And then just briefly, as relates to the child's well-being, I know that we've heard from Mr. Howitt on a few of the issues that she's been experiencing this review period, but is there anything else that you would like the court to know about how the child's doing?
Just that since I submitted the court report, she is doing better. It's been kind of up and down in general this reporting period, but she is meeting with a new psychiatrist, and CMH felt that she had maximized therapeutic benefit. So foster parents have located a different therapist that she's on the wait list for. And since her current medication regimen seems to be working for her, so she does appear to be stabilizing, which is good news. And the school has been working, they developed a formal behavior management plan that's been implemented, and we meet as a team once per month to discuss how she's doing in school and any concerns and how to address them. So everyone is being very proactive and meeting her needs and making sure that we can help her stabilize.
Thank you so much. I have no further questions of Ms. Beach, Your Honor, and would ask the court to accept the court report at this time.
Any objections?
No, Your Honor.
No.
Thank you. They are received. Questions for this witness, Ms. Sador?
Just briefly, you were in contact with Ms. Collier regarding her health, her own reported health update, though, correct? Okay, and that she had surgery and was recovering?
Yes.
Okay, and that you also received a box she had sent for the child for her birthday?
Yes, I just received that on Friday.
Okay, all right. I think that's it. Thank you.
Questions, Mr. Howitt?
Yes. Has Ms. Collier or her attorney reached out to you for an update, or do you typically give them updates?
I typically give them updates in an effort to maintain regular contact with them.
Nothing further.
Any redirect?
No, Your Honor. Thank you.
Any other witnesses?
No, Your Honor.
Thank you for your testimony. We return to you. Ms. Sador, anyone you'd like us to hear from today?
I'd just like to briefly call my client.
Deputy, would you swear in Ms. Carla Collier, please?
Raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
She's got to unmute. There you go.
I apologize. Yes, sir.
Thank you.
All right. Hi, Carla. Just want to update the court since there wasn't a release signed in time to get medical records or anything. Can you please tell the court what your current health status is?
Currently, I am almost fully recovered after having a hysterectomy. Not something they do often for someone my age, but it went well, and I am working through cleaning different people's homes and the churches, something that I couldn't really do very well before. So yeah, I had a hysterectomy, and they were able to correct internal damage caused by my abuser.
Okay. And then in terms of working, has your doctor limited your ability to do regular work while you're recovering?
I am able to do basic stuff. I still can't lift anything heavier than 10 pounds or whatnot, but within the next 2 to 3 weeks, I should be cleared to work fully.
Okay. And you sent a box for Uta's birthday, is that correct?
I did.
And what was in the box?
In the box was, because her thing is, we love moose. We're a part of our family thing. A moose purse so she can hold things as she goes and plays. A book that we used to read together. I can't remember exactly the name of it. Stellella, I think, or something. Stella Luna, I believe it is. And an outfit that I thought she would enjoy having, because we enjoyed clothes shopping. And just a bracelet with a moose on it that says how strong she is and how much she's loved by everybody, not just me, but those who are caring for her now. Yeah.
Did it have a quilt as well, or no? Are you still working on that?
I'm working on the quilt.
Okay.
And
then, in terms of the meetings that Ms. Beach had testified about, the one with the school, were you able to attend that meeting virtually?
I was never sent a link, and I can send you proof of that after, whenever is convenient if needed.
Okay, so you didn't attend that one, but you wanted to, is what I'm asking.
I very much wanted to. I'm very grateful. The school has done a wonderful job in helping her.
All right. Thank you. That's all.
Any questions, Ms. Thomas?
No, Your Honor, thank you.
Mr. Howitt?
No, Your Honor.
Any other witnesses, Ms. Sador?
No, sorry. Thanks.
Mr. Howitt, anyone you'd like us to hear from?
No, Your Honor.
Very well. Comments in closing, beginning with Ms. Thomas?
Your Honor, we are just requesting or renewing our request for the relief put in our petition. I think at this time, the child has waited a significant amount of time to achieve permanency and finality. And I'm grateful for Ms. Collier taking the opportunity to give the child, it sounds like a really meaningful gift basket for her birthday, and that mom's able to address her own physical health needs at this time. However, given the length of the time that this case has been open, the active efforts that were employed, I don't believe that there's a significant change of circumstances in which we could, in good faith, ask the court to withdraw our request for termination to allow the child to be adopted. And so we are just asking the court to issue its ruling so that this child can move forward. Thank you.
Mr. Howitt? Oh, I'm sorry. Let's go to Ms. Sador first in case there's anything you want to respond to. Ms. Sador?
We would still rely on our closing statements that were written that we submitted after the trial. We are awaiting a ruling. And again, we would ask that you deny the termination petition. Thank you.
For purposes of the review and permanency planning hearing, the court finds all interested parties are given notice for purposes of today's hearing. The hearing is a consolidated and continued termination consideration request as well. The child continues to be in the safest and least restrictive placement with a necessary and appropriate goal of adoption in this case. She continues to struggle mightily with some of the diagnoses that she suffers, some potentially identified as genetic at this point, but many more that have been documented by different service providers and analysts, including through trauma assessments, psychological evaluations, IEP evaluations, and just regular interaction with her, as certainly being outgrowth of the trauma that she suffered before being removed from the care of her mother September 1st, 2023, just before the age of 4. So the lack of progress on the case services plan continues to be persistent. The active efforts of our agency are certainly above and beyond even, I think, what has been considered in many other cases. And so I do want to take a moment to recognize those efforts. A good example that Ms. Beach highlighted in her testimony is that weekly or biweekly reach out. Typically, last time I checked, at least the foster care manual indicates once a month reaching out. Certainly not weekly or biweekly, certainly not emailing updates and invitations at the frequency that the department has done so. And especially in this case where we had a significant period of complete disengagement, I just want to say that I really think that the professionalism of this agency has really been highlighted in this case by their willingness to re-engage. Francesca Madrid and some of the other caseworkers, I'm sure as well, suffered through a lot of accusations and very difficult parenting time sessions. And I'll go as far as to say punishing and humiliating episodes in attempts to try to move this case along and fulfill obligations to provide active efforts in this case. And we certainly have done that, and the child has benefited from that at least, but there has been no significant benefit that would allow me to find that the risk of harm associated with returning this child to the parent has been alleviated. And I'll articulate more of that in the written opinion that I have before me today, that I will read onto the record so that you all won't have to wait for this to come to you by email or by mail, and you'll have a thorough decision on that point. So I'll go ahead and get into that now. The court's been asked to consider termination of parental rights pursuant to MCL 712A.19b, subsection 3A(ii), CI, and subsection J. In short, the first section considers abandonment, the second considers progress on case services, and the third considers the risk of harm, which is similar to what the court has already and has articulated on at each review hearing. The case concerns Carla Collier and her daughter born November 9th, 2018. The Lenawee County Probate Court received and granted a petition for emergency removal and jurisdiction from the Department of Health and Human Services on September 1st, 2023. The child was 4 years old. Actually, I think she was 3. She turned 4 shortly after that in November. The preliminary hearing was conducted over several dates, September 1st, September 25th, and October 4th, 2023. The caseworker testified. The case was immediately recognized for ICWA-MIFPA considerations, and the native village of Buckland, Alaska was asked to join. The QEW for the tribe agreed that removal was appropriate, of paramount importance for the following issues. And I just want to pause for a moment here and say I understand the tribe's not with us today. There was extensive cross-examination of the QEW, the same qualified person, I'll note, the QEW at the outset of this case, and also was present at the last hearing. And there haven't been significant changes in those circumstances that would require me to require the tribe to reappear to articulate the same findings, because nothing's really changed. So I'm moving forward even without the tribe today because of those reasons. And I think the comments by the tribal representative last time that are considered later on in this opinion also support that, which is, in her opinion, 6 months would have been sufficient. Rather than the nearly 25-month mark that we are at now. So back to the findings. Of importance were the following issues. 1, transience and homelessness. The September 1st, 2023 petition indicated that Carla Collier had lived in 10 states in 2 years and gone from shelter to shelter and was even attempting to turn her child over to a person in Canada whose identity was unable to be confirmed. After the filing of the petition, this pattern continued. At the September 1st, 2023 preliminary hearing, Carla Collier was found in Adrian at a hotel funded by the MDHHS on a temporary basis, since she had been asked to leave the local domestic violence shelter. At the continued preliminary hearing on September 25th, 2023, she appeared from a campground in Kentucky. At the second continuation of prelim on October 4th, 2023, she was somewhere in Seattle, Washington. At the time she entered her no contest plea, she was still somewhere in the state of Washington. There was no city or address specifically offered at that time, and that was November 3rd of 2023. Paragraph 2, child abuse concerns. Both while she was at Catherine Cobb Shelter in Adrian, Michigan, as well as when the child was removed in the state of Washington, there were concerns for physical discipline that was abusive, including things like food deprivation in response to trauma behaviors, inappropriate discipline for trauma-related behaviors, and mental health issues, including potential sexual abuse at a very young age when she, quote, left the child with her ex-partner at his residence in Alaska for 2 weeks, with 16 other individuals coming in and out of the house who were alleged to have sexually abused her while Carla was staying at a local hospital. And that was an excerpt from the petition, which was drawn from the records in Washington. 3, child neglect concerns. Records reflected removal for 6 months in Washington state for these and other concerns, including failure to ensure seizure medications for her child. 4, improper parenting. When mother and child arrived in Adrian, she was reported for concerning parenting while staying at the local Catherine Cobb domestic violence shelter. MDHHS attempts to prevent removal included programming called Families First, as well as support from the staff at the Catherine Cobb domestic violence shelter in Adrian, Michigan. Despite these efforts, she was asked to leave, having refused to cooperate with the rules of the shelter, refused to change any dangerous parenting patterns, and even referring to another resident's Black child as an animal at the end of her stay. On November 3rd, 2023, respondent Carla Collier asked to enter a no contest plea, asking the court to take judicial notice of the testimony offered by the department at the preliminary hearings and effectively admitting the facts outlined in the petition. At that hearing, the tribe did not appear, despite notice, so the court took the plea under advisement. Even at this early juncture, however, parenting time had to be reviewed and reduced due to behaviors triggered during and by mother's virtual visits. Observations of the child included, quote, she repeatedly yells she wants to end the call. She gives looks to the workers when we try to fix the phone for her to be able to see mom. She will purposefully not answer, and then just immediately after the visit, I struggle to redirect her and get her to settle down again. And then there are the reported behaviors from the foster parents in the home, end quote. The child at age 4, at this point, expressed self-harming behaviors and struggled with even seeing her mother on the screen without a negative reaction, both visibly and audibly. She would repeatedly slam her head against a wall, tantrum, refusing to allow anyone to help her. Compounding frustration from caregivers and the child, mother simply ignored her child's feelings expressed during these visits. The foster care caseworker was already acting quickly on referrals for the child. Trauma assessment was scheduled for 11/28 of 23. The child was already being seen by Mia Hamden of Lenawee Community Mental Health Authority for play therapy and scheduled EMDR. But this professional did not want to weigh in on parenting time. The court confirmed the worker should find another professional to weigh in to assist in addressing future parenting structure. But to preserve the child's mental health and physical, the court reduced contact between mother and child. On November 17th, 2023, A disposition order entered with a case service plan for Carla Collier aimed at reunification. Carla Collier had returned to Adrian and was staying in a homeless shelter. She continued struggling with transportation, housing, employment, and had not engaged in voluntary services as of yet. The child remained eligible for enrollment in the village of Buckland with her father's family out of Buckland, Alaska, and efforts to complete registration were underway, as well as out-of-state relative placement inquiries. Mother was asked to undertake psychological evaluation to help discern and overcome the reasons for her failure to benefit from prior services in parenting education and to help stabilize her own life. She was asked to establish a safe and stable environment for herself and her child, including housing, employment, parenting education, and other services. Regular quarterly reviews were conducted until the supplemental petition for termination of parental rights was filed on March 21st, 2025. Initially, Carla Collier was engaged in making efforts to undertake difficult therapeutic work to reunify with her daughter. At the first regular review hearing in February of 2024, she was still in Adrian, living with a friend, working at Chipotle, and seemed to be safe during parenting time and bonded with the child. She was engaged in CMH therapy, including EMDR, trauma-informed parenting classes, and participating in UTIS trauma assessment. She even completed her own psychological evaluation February 5th of 2024. There was still significant concerning incidents, however, including threatening to kill Cameron Kuzic, the Child Protection Services investigator, and another CMH caseworker. She was also insisting she wanted the child raised Norse pagan and wanted her child singled out against Christian prayers and chapels at school. The tribe was also, unfortunately, continuing to be absent for reviews, but it was clear the foster care caseworker was using active efforts in engaging mother, providing transportation, ensuring frequent and regular interaction with mother, hands-on assistance, and applying for housing, employment, and other referrals. Meanwhile, the child's story continued to unfold, only to demonstrate increasing special needs and complicated trauma-based behaviors. She was reportedly doing well in her placement, despite a PTSD diagnosis from the trauma assessment initial analysis. She continued to frequently demonstrate aggression towards others, becoming easily overwhelmed and needed regular use of isolated safe spaces. Supported in visitation using family therapy, including a referral for attachment therapy with mother. She was engaged in occupational therapy for sensory processing work and work on fine motor skills for developmental delays. At the second review, May 16th, 2024, mother remained living with a quote support person, S, quote, we weren't sure how many people were living there or who was living there. She was still employed part-time at the local Adrian Chipotle, exercising limited supervised parenting time. There were uncommon concerns about a quote support person, quote, for mother, who had to be delivered a cease and desist letter from the department, and I think it was actually the agency, for hundreds of accusatory text messages, complaints, and harassment. This person, unsurprisingly, was prohibited from being around the child. It was further noted that this appeared to be an extension of a pattern already noted by the prior caseworker in the Washington State case interventions, specifically the observation that mother tended to, quote, make quick connections with support people who may not be appropriate for her child to be around, end quote. Of additional note, mother had voluntarily terminated services through Lenawee County Mental Health Authority, citing her dissatisfaction with the, quote, professionalism, quote, of her caseworker. Her psychological evaluation revealed significant trauma in mother's past, which appeared to continue to interfere with her overcoming the barriers to reunification. Evaluation from Adrian Counseling and Psychiatric noted, quote, she has the following diagnoses: major depressive disorder, recurrent, moderate, generalized anxiety disorder, attention deficit hyperactivity disorder, combined type, and post-traumatic stress disorder, chronic, end quote. Several medications were indicated. It was clear she needed to continue and even double down her efforts. Despite her child removed from her care September 1st, 2023, by May 16th, 2024, she still had no independent housing, no income sufficient to support herself without an arguably dangerous support person, and no regular or sustained individual therapy progress. She had no transportation, and a strange and continuing pattern of involvement with people who compromised her progress with the caseworkers, therapists, and referral service providers. She also seemed to be fixated on ensuring the child was safeguarded against understanding or practicing Christianity, effectively undermining the placement's efforts to provide private Christian school education for the child and participation in foster family activities like church on Sunday mornings. There were concerns about her referring to someone her child never met as daddy during parenting time, and use of some language she claimed only her and her daughter knew. Mother had demonstrated stability in only one area in this extended review period, maintaining part-time employment at Chipotle. Her efforts to undermine the stability of her child's placement with special requests to change school, daycare, and avoid church were not enough to distract the court from recognition of her lack of progress during the report period, and the child remained in foster care. The trauma assessment indicated, quote, an insecure, ambivalent attachment style, quote, between Carla and her child, which did seem to reflect the very real pattern for Carla of being radically present in some ways and radically unreliable in others. Relative placement investigations through ICPC were denied for non-participation by potential placements. The tribe did not appear. At this review, a deluge of information about the child was available and reviewed. The child's trauma assessment indicated indications for neglectful home environment, emotional abuse, exposure to domestic violence, impaired parenting due to mental illness, prenatal exposure to alcohol or drugs, and/or maternal stress during pregnancy, lengthy or multiple separations from a parent, placement outside of a home, and frequent multiple moves, and homelessness. A bonding assessment for mother and child indicated that based on the observed interactions between them, they were determined to have an insecure, ambivalent attachment. The assessment indicated PTSD in a child under 6 with a possible overlap in symptoms indicating autism, which has not been confirmed. There were developmental delays, indications of sexual trauma, memory and emotional control difficulties, significant needs. It is clear any caretaker would have to have elevated skills, tools, and flexibility to address the symptoms identified. Carla was referred to Brene Moore for therapeutic parenting time with her daughter to work on attachment and bonding therapy, among many other referrals from the psychological assessment. As of the hearing, she had not made any contact with Ms. Moore. August 15, 2024 marked the third review for Carla Collier, 7 months after Uta's removal. Carla remained living with a support person who passed clearance. However, someone new had moved in shortly before the review who still needed to pass clearance. She was no longer working at Chipotle, claiming to be part-time in a new job. She was attending individual counseling, but the counselor reported she was still working on Carla's defensiveness and understanding why her child was removed from her care. Carla still had not reached out to Brene Moore for attachment therapy with her daughter, despite repeated reminders from the caseworker. Her previous request for email delivery of information only was now a problem in communication. She also claimed a traumatic brain injury and a hospitalization in the last report period. She also continued to try to interfere with her child's foster home practices, asking to change to public school, despite her child's clear need for stability. She also indicated on the record that she had not even read the court report. Issues with mother's housing, employment, sustained mental health treatment, and parenting education remained significant barriers, and the child remained in foster care following the hearing. The child went her first full report period without a seizure. She was in 2 kinds of therapy pursuant to the trauma assessment recommendation. Once for individual therapy, twice weekly in-home. She underwent a psychiatric evaluation, including several diagnoses, such as ADHD, PTSD, and disinhibited attachment disorder, and was prescribed medication for the ADHD symptoms. She was using ankle braces to assist in walking and stability and attending OT-PT therapy as well. That's no less than 4 appointments weekly, not including T-ball, dance, or tutoring to get her ready for kindergarten. November 12th, 2024 marked the 4th review hearing for Carla and 10 months of foster care for her child. Carla Collier was, quote, couch surfing after being kicked out of her support person's apartment and had no verifiable employment. She appeared to be decompensating in her mental health, demonstrated by accusing caseworkers of stealing her belongings, being threatening and aggressive to her. She missed appointments for the child. At one point, the caseworker had to take an emergency call to consent for services for the child to get necessary medications. She was dropped from the supportive visitation program for lack of participation. She had attended the intake appointment with Brene Moore for attachment therapy, and I'll note here that the caseworker drove her to that appointment. But when she got there, she stated she did not know why she was there and never followed through. That was from the report period. Most painfully, she stopped visiting with her child abruptly as of October 21st, 2024, claiming, quote, that if she didn't get a new caseworker, she wasn't going to be working with the agency or visiting with her child, end quote. The court report contained many other examples of Carla's intentional negative commentary, and even one episode of complete emotional dysregulation and screaming at caseworkers. The caseworker had to ask for her visits to be suspended due to the effect these behaviors and missed visits were having on the child's mental health. The child made gains during that report period, transitioning into kindergarten well. She had reduced reliance on her ankle braces and only had 1 non-emergency seizure that report period. She still attended weekly PT, OT, and individual therapy with psychiatric supports and had her educational IEP in place as well. The agency was asking for a goal change to adoption, which was not addressed on the record that day. The order reflected continued placement in foster care appropriately due to lack of housing, financial support, and other circumstances reviewed by the court constituting substantial risk of harm in returning the child to Carla. The January 27, 2025 review and permanency planning hearing was the sixth review for Carla. Unfortunately, she appeared to be in the downward trend of stability with unknown housing, no employment, and a complete disengagement from services, and no contact with the department or her daughter after some very vitriolic text messages sent November 14th and November 30th, 2024. The goal was changed to adoption for the child. She was 6 years old and had been living with her foster family for 16 consecutive months. She appeared to be still gaining progress due to the stability and service supports in place. She had only a singular seizure, was still participating in OT-PT psychiatric care and therapies through CMH. She missed her mother and openly spoke about it at school. The school continued to support her as well with IEP reviews and accommodations for behaviors when she struggled. The department was ordered to file a termination petition at that review. The petition was filed March 21st, 2025. By the time the supplemental petition was filed, in addition to the issues identified at adjudication, the child's father had released his parental rights and her mother had effectively abandoned her. Following the petition for termination, respondent parent Carla Collier resurfaced from a church in Alaska that had allowed her to reside in an apartment on the grounds, provided her retained legal representation and even transportation from Alaska for hearings. She reemerged on the back of this new support system for the remainder of these hearings, starting with the April 21st, 2025 hearing. Carla Collier reappeared in person with a retained attorney from this new setup. She came in person for at least one of the hearings. The April 21st hearing was also the one scheduled for the termination petition to be heard. Her attorney requested to adjourn, and the court granted that request to allow the attorney to review the file and try to assist Carla in preparing for that termination trial. The seventh review and permanency planning hearing, combined with the hearing on the March 21st, 2025 petition for termination of parental rights filed against Carla Collier, recommenced on May 30th, 2025. At that hearing, Carla Collier's complete absence from her daughter's life and services was documented from October 21st, 2024 through to the appearance and request for adjournment on April 21st, 2025. She produced a letter from Love Alaska with a case management plan that documented she was due to engage in therapy, but had not yet done so. Her mental health did not appear to have improved. Strangely, she claimed she had vertigo, bleeding episodes, and even that walking was hard for her due to issues with the way my heart pumps blood through my body, quote, and that she had two older children, she had not seen since they were infants. Carla continued to insist that her child was taken from her based on lies and that the caseworker was intimidating. She went on to include her first therapist, apparently from 2023 as well, in accusations of intimidation in her testimony. Her attorney had to redirect her more than once during her direct examination to get Carla to answer questions that she'd been asked. The child remained steady during this report period, still in her therapies and supported at school. The native village of Buckland was noticeably absent at the outset of that hearing, and without a QEW, the court continued the hearing as to the termination trial, but conducted the review. Carla was provided with another copy of the petition requesting termination for review and preparation. An eighth review and continued termination trial commenced July 14th, 2025, some 23 months after the child's removal from her mother, and still nothing had changed. At this point in the case, the main worry with completing the termination proceedings was ensuring that the department had met their obligations under ICWA and MIFPA. The tribal representative had changed for the village of Buckland several times. Joe Washington appeared, but was unwilling to express an opinion as to whether or not termination served the best interests of the child. The department requested a continuation to explore if further input could be had from the tribe. Carla had been offered assistance in searching for services in her area in Alaska, but had declined. She also remained unengaged in any services voluntarily, even though the Love Alaska group that offered support for her, had offered support for her, at least through individual counsel. The child's seizure disorder remained well supported, as well as her special educational needs and her behaviors, but her behaviors and self-harm began to truly plague her during this report period. The foster family and the department were supporting for additional autism testing, including for genetic markers and abnormalities. She continued to ask for her mother, despite her mother's 6-month absence at this point. The eighth review recommenced August 20th, 2025, just 11 days shy of 24 months after removal. Native Village of Buckland representative Frederica Gavin appeared and testified in the capacity of qualified expert witness. She confirmed she too supported termination of Carla Collier's parental rights. Of note, she was the original QEW testifying at removal and indicated she would have expected this parent to remedy the issues within 6 months of removal. A July 3rd, 2025 email update from Love Alaska representative Rebecca Sullivan indicated Carla was being tested for the same rare heart condition Ms. Sullivan suffered, called postural orthostatic tachycardia syndrome. She indicated this may be the reason Carla had yet to begin her counseling or make any progress in obtaining regular employment or transportation. The child was reported as doing well in placement. Remarkably, towards the end of this hearing, an unidentified person present by video with Carla Collier offered the camera her middle finger. Frankly, this was consistent with Carla's involvement with the Michigan courts and the agency, but still surprising. Due to the attorneys in the court engaged in conducting the hearing, the gesture initially went unnoticed. The court allowed the parties to submit written closing arguments and indicated a written opinion would be forthcoming, but scheduled the next review and continuation of the trial as well. This final review is held November 17th, 2025. Altogether, Carla Collier was given over 25 months to rectify the conditions that brought her daughter into foster care. She remained without employment, wholly dependent on the goodwill of the church in Alaska for housing, and without any engagement in services in the last report period. The child still struggles mightily with the effects of her mother's parenting in the first few years of her life. Her seizure disorder is well maintained, but treatment for delays and trauma behaviors continues to be a winding maze for her and her foster family. Upward progress is significant for her and requires enormous support, analysis, and services from all the people in her life. Return to Carla Collier, who has made no progress and his sister daughter was taken from her based on lies, would most certainly put her in harm's way again. Very real physical, mental, and emotional danger. The court is asked to consider termination of parental rights pursuant to MCL 712A.19B3A2, 3CI, and 3J. The court may terminate a parent's parental rights to a child if the court finds by clear and convincing evidence that the child's parent has deserted the child for 91 or more days and has not sought custody of that child during that period. Carla Collier refused visitation and abandoned her child effectively October 21st, 2024, and truly remains gone. Engagement with the court resuming at the April 21st, 2025 hearing seemed to be at the insistence and facilitation of mysterious support people from Alaska. Even recognizing her re-engagement at court hearings in April of 25, the statutory 90-day period to measure abandonment was already met by the substantial 182-day timeframe she was completely disappeared. Re-engagement did not mean into services either, which left all risks associated with parenting time continuing to prevent her from even visiting with her daughter. So there is clear and convincing evidence of abandonment under 3AII. 3CI the court is asked if the parent is a respondent in a proceeding brought under this chapter, 182 or more days have elapsed since the issuance of the initial dispositional order, and the court, by clear and convincing evidence, finds either of the following. The applicable subsection is I. The conditions that led to the adjudication continue to exist, and there is no likelihood that the conditions will be rectified within a reasonable time considering the child's age. Hand in hand is section 3J, which is whether or not there is a reasonable likelihood based on the conduct or capacity of the child's parent that the child will be harmed if the child is returned to the home of the parent. Carla Collier has been a respondent subject to case services planning, offered active efforts towards reunification. For nearly the entire 25 months her daughter has been in care. She hasn't seen her daughter since October 21st, 2024, nor ever engaged in any real way with services to truly benefit herself. The pattern of depending on others noted in the Washington case persisted throughout the case in Michigan and continues for her in Alaska even now. Her brief engagement in services saw Carla's best efforts early on in this case. But even then, the biggest problem was her inability and unwillingness to recognize how her behavior and choices affected her child. She has never truly taken responsibility for the trauma and injuries to her child, nor engaged in any therapy that may have truly allowed her to do so, by way of example, the attachment therapy. She simply left in November of 2024 and has not returned. It seems the support people she has now are more interested in her appearance and participation in these proceedings than she is, receiving very little cooperation from Carla in their own attempts to support her in individual therapy services. Given that this is the pattern that has been in place for over 25 months in this case, and then 6 months in Washington before that, and likely many years before that even, especially if it's true that there are 2 other children out there, it is clear and convincing that there is no reasonable expectation she will remedy these risks in a reasonable time considering the child's age. Return to Carla Collier, who has made no progress and insists her daughter was taken from her based on lies, would most certainly put her in harm's way again. very real physical, mental, and emotional danger. If the child were returned to Carla, she would have no reassurance that the home that they are in would be stable. Even Carla's Love Alaska support person referred to the apartment as a temporary solution. The child would have no guarantee she would have the food and clothing she needs because Carla remains unemployed. She would be unable to rely on Carla for transportation to the many appointments for physical therapy, occupational therapy, trauma therapy, or even education she needs, as Carla still has no driver's license or reliable transportation. And worst of all, there's no guarantee that Carla would not expose her to physical abuse at her own hands, sexual abuse at the hands of others, or simply just neglect her needs on a global basis. There's no question that there's a reasonable likelihood, based on the conduct or capacity of this child's parent, that the child would be harmed if the child is returned to her home. The best interest considerations. The court considers a number of factors as to the best interest determination to conclude that there is a preponderance of evidence supporting termination of parental rights in this case. A summary in the November 10th, 2025 court report highlights important considerations as to the child's special needs. And I'm quoting, presume the speech here. The current placement is in the child's best interest, as it is the least restrictive and most family-like placement available to her at this time. The foster parents are committed to meeting all of her needs, and they have an understanding of the child's trauma history, as they have had placement of Uta since she entered care over 2 years ago. In addition, the foster mother is a trained therapist with knowledge and education regarding how trauma impacts the child's development and behavior. The placement is willing to provide her with permanency through adoption if reunification with mothers unable to occur. The placement continues to meet all of Uta's physical, medical, developmental, and emotional needs. End quote. The lawyer guardian ad litem offered support for termination in his closing arguments and in support of the goal change many months ago. Finally, the QEW for the native village of Buckland also supports termination, rounding out all available experts considered in this case. There's also the matter of the parent-child bond to consider. The attachment between this mother and child was characterized early on, quote, an insecure, ambivalent attachment style, quote, between Carla and the child, signaling the child and mother did have affection for one another, but it was characterized by mother's inconsistency, danger during periods of untreated mental health, lack of parenting skills for her special needs child, and even her negligence in allowing sexual trauma against her daughter in the past. The child seemed unfazed by some of her mother's very real emotional outbursts, behavior during visitation, further supporting this court's conclusion that the bond between mother and child caused more harm than good for Uta. She refers to her biological mother as Carla and to her foster parent as mother. She looks to her foster mother to provide the many services, both regularly and extraordinarily, and the foster home has gone above and beyond to secure evaluations, therapies, extracurricular activities, and even private school education for the child, welcoming her into their family, never giving up on her when her behaviors make it heartbreakingly difficult. They have introduced her to Native traditions, maintained connections with her family, Native family members, secured as much information about her heritage as possible, and even honored Carla's request to introduce her to Norse pagan practices, hanging Native and Norse pagan prayers up and engaging with her to ensure she understands them. She has bonded with the civship she is a part of in her foster home, a stark contrast against the opportunity to attempt to engage with her own biological siblings mentioned by her mother, if it is really true that Carla Collier has 2 other older children. She had no information as to the whereabouts or family for the department to even explore for placement. There is no question this child is in the best placement for her to continue her trauma recovery and work on meeting her developmental milestones and where she is now. She's been living in this home since she was 3 years old and is now 7. She has a heightened need for stability and permanency that has been delayed far too long by these proceedings. Therefore, it is the order of the court, the parental rights of Carla Collier to Uta Collier are terminated effective immediately. There will be no more efforts towards reunification or to prevent removal. I'll set a post-termination review hearing. Ms. Collier certainly has a right to appeal, and all of that information will be sent to her, as well as the information as it relates to how to continue to keep her information updated should she choose to do so with the department, in the event that her child wants to ask for that information when she hits the age of 18. Unless there's any questions, that's all for today. And I'll go ahead and give the review hearing date after we're offline, because we'll be proceeding under the adoption code from this point forward. The child's father has released his parental rights, and the child will be committed to the Department of Health and Human Services for purposes of adoption, and all proceedings under the adoption code are confidential.
I believe my client is raising her hand. I don't know if the court would entertain a question.
I would invite you to speak with your client, Ms. Sidor.